on the following. The warrant upon which Mazi Kanu was arrested was issued by a federal high court in Abuja. Warrant of a federal high court in Nigeria is not valid for effecting an arrest in Kenya. Kanu did not undergo extradition proceedings in Kenya. Extradition is a condition precedent to the assumption of jurisdiction of a court over a fugitive suspect returned from overseas. So the condition precedent was not met. That's a challenge to jurisdiction. Then we have Article 12, Sub 4 of the African Charter on Human and People's Rights, ratified in Nigeria in 1979 and codified as part of our laws in 1983 that prohibits unlawful expulsion of Africans from one country to the other. Yes. And we have the continental counterpart that prohibits as such. It's our position that Mazi Nnamdi Kanu's exit from Kenya was unlawful expulsion that robs this honorable court of jurisdiction. So we are not talking only international law here. There's a misconception that, hey, Ejimako is talking about extraordinary rendition as if it's out of the blues. No, even our constitution prohibits extraordinary rendition. When the constitution said at section 35 that nobody shall be subject to arbitrary or unlawful arrest. What does that tell you? It means the constitution says extraordinary rendition even within the domestic territory of Nigeria is unconstitutional and is illegal. So the arrest or what happened to Nnamdi Kanu in Kenya was arbitrary and unlawful. These are our positions and they are very, very clear. We have these Nigerian authorities to support all these things, and that is why extradition is important, and that is why United States, with all her military might, came to Nigeria. They want our top policeman, Abba Kyari. They didn't take him by force. They approached the Nigerian government. They have the military, everything, but they are approaching our courts to issue an order that is called an extradition order or extradition warrant. So why didn't Nigeria respect Kenya? If Kenya cannot come to Nigeria and grab anybody and take them back to Kenya and subject them to trial, why should Nigeria be allowed to go to Kenya and grab anybody without authority of law?
Okay, sir. Okay,
and
sir.
Subject them to trial.
Sorry, sir.
So that is our case in chief.
What happened in court today?
What happened is that, I have said it before, we were outside consulting because there was a mild disagreement as to the number of lawyers that should be allowed inside the courtroom. So we left our books, wig and gown, outside and went outside. The judge had not come to put heads together in a civil conference with DSS officers to resolve the issue of how many lawyers that should go inside. Lo and behold, the judge came into the courtroom and ordered that we be locked out. We didn't know this. So somebody told us the court, judge is inside it. So we broke up and went to the door to go inside the courtroom, but the door was locked. We banged. DSS officers banged. They refused to open the door. The judge proceeded to conduct ex parte hearing when lawyers are in court. A criminal defendant who was rendition since June in poor health, she conducted ex parte hearing and adjourned the case on her own motion to 19th and 20th of January next year. The law says this kind of case is day-to-day trial, that the maximum number of days or whatever period of adjournment allowed under the law is maximum is 2 weeks. So why this? We don't think it's fair. Justice should not be done, but should be seen to have been done. Thank you.